good morning and welcome to News on the Block's Leasehold Knowledge Week. We're halfway through the week and we've just got 4 sessions left. Thank you to all our sponsors: Chandler Harris, Pearlygate Maintenance, BBIS Commercial Heating, Foresight Realty Law, Blackguard Insurance, JPC, Towergate Insurance Brokers and PLP Fire Protection Service for your continued support. So in our first session today, we're going to be discussing the trials and tribulations of managing an RTM block, which will be presented by Sarah Goodall, Senior Associate at Shoosmiths. Sarah specialises in residential long lease property, specifically enfranchisement, right to manage claims, residential service charge issues, breaches of lease, Landlord and Tenant Act 1987 disposals. She acts for a mix of developers, investors, tenants, managing agents and RMCs, and Sarah was named Young Professional of the Year at News on the Block's Enfranchisement and Right to Manage Awards in 2019. She's a member of the Association of the Leasehold Enfranchisement Practitioners. Sarah is going to be here till 11 o'clock today, so please use the session wisely, answer as many questions as you like, and she's going to answer them throughout the whole of the session. So I'm going to hand over to Sarah now. Sarah, hello. Good morning. How are you today?
Yeah, I'm good. How are you?
I'm very well, thank you. It's lovely to see you. I'm looking forward to your session, and hopefully we'll get lots of questions. And I've suggested that everyone uses your session wisely and asks as many questions as they can.
Okay, good.
So
Thank you.
Over to you.
Okay, morning everyone. I wish I could see you all, but I can't. So I'm trusting that you're not just having me on in the background and you're all paying attention. Not really. You can do what you like, but if you could engage, that would be great. So my session today is on the right to manage. I've tried to make it less legal dull and more practical, and for that reason, given that a lot of you have more practical experience than I do, obviously if you want to engage, you want to share any stories, you want to ask any questions, then feel free to get involved whenever you like. I'm hoping that I'll be able to see the chat function pop up somewhere. I'm not a Zoom expert, so we'll see what happens. I'm sure Charlotte can prompt me if I'm missing anything. But so let's kick it off. As I say, it's the trials and tribulations of managing an RTM block, of which there are many. Obviously, most blocks will be managed fine, but occasionally there are issues. So this session is really looking at those issues and some practical things that you can do to minimise risk. So very briefly, just a reminder of the right to manage process. I quite often get approached by managing agents who've been in turn approached by tenants saying, we want you to manage the property. So I know that managing agents can get involved in this process. Really the main things for you to remember are whether or not the building qualifies, which at the moment is typically a building of 2 or more flats. Whether you'd want to manage a building of 2 flats is up to you. No more than 25% non-residential part, and obviously it has to be a building or part of a building, and if it's a part of a building, it needs to be capable of vertical severance and service separately. So if you're happy that the building qualifies, then it's a case of really getting the involvement. So you need 50% of tenants to participate in the process. They in turn need to invite everyone else, and then they can proceed to serve their notice of claim, which will claim the management in 3 months' time, or a minimum of 3 months' time. So I won't go into too much detail on that because that's really what I would do, but just so you're aware of the process, it's all there, and you're going to get a copy of these slides after the session. So what are the benefits of the right to manage? Well, you get control over the management of the building and potentially the estate, which we'll be discussing later because I'm sure you know that can cause issues. Ability to select a managing agent of the tenant's choosing, and as I say, we generally get approached when the tenants have got a managing agent in mind. Peace of mind regarding insurance, that's not always applicable, but sometimes leaseholders get concerned that they're not sufficiently covered and the landlord perhaps isn't forthcoming with the information despite requests, so at least they can arrange that themselves. Easier approvals, so again, something we'll be discussing later, but where tenants want to alter their property or to sublet, theoretically it's easier when there's an RTM in place. And then obviously reduce management costs, and that's one of the big drivers here, is that tenants feel that they're being ripped off and they want to take control of the management, so they get to choose. Again, it doesn't quite work like that in practice, but that's the idea and one of the drivers behind it. So what are the trials and tribulations? Well, there are many, but estates is a big one, and it's kind of a hot topic at the moment. So where you've got several blocks in one estate, there's huge issues coming out of that. Finances, so right to manage company don't have any funds of their own, so that can cause problems. Enforcement, again, limited enforcement rights when you're a RTM company, so that is an issue. Consent, so I said earlier that theoretically getting consent to items in the lease is easier when there's an RTM company, but actually when you delve into it, it's not so easy, and this is an area that people quite often get wrong. So we're going to talk about that. Briefly talk about the handover and the issues that can arise there. I'm sure some of you have been involved in an RTM handover and experienced these issues yourself, so we'll have a look at that. And then obviously the relationships, and there's relationship issues whenever there's a building of people living together, but RTM is one of these where relationships can be disrupted. So let's have a quick look at I say quick, actually, this is probably the longest section because there's so much wrong with it, but the problem with estates. So where this kicks off was the Gala Unity case. So it was determined long ago that RTM company could only claim the RTM of one building. So where you've got an estate, you can't have an RTM company that claims the RTM of all 8 buildings, for example. They can only claim one. So the other 7 buildings need to sort themselves out effectively. What Gala Unity said, however, is that when an RTM company claims the RTM of one block, they're also potentially, and it is facts dependent, but they're also claiming the right to manage of the estates as a whole, whether they like it or not, and that's excluding the blocks, but including anything that can be deemed to be appurtenant. So for example, gardens, parking spaces, etc. So the Gala Unity case determined effectively that that's what the leaseholders were getting when they're exercising the right to manage over an estate, which has caused a heap of problems. This was really dealt with again in the first port case, which I've listed there. Essentially what happened in that case is that there was an RTM over one block. First port were obviously obliged to maintain the estate pursuant to the leases of the other blocks, so they did. And the upper tribunal determined that they couldn't recover those costs from the RTM company because it was an RTM obligation. As I understand it, that case has been granted permission for a leapfrog appeal, so we'll see whether the Supreme Court can sort the mess out. So I've got a bit of an example here. So I don't know what this building is. It's not one I've worked on. Maybe someone here recognises it, but it's just for example purposes. We've got a block A there who, in my example, have claimed the right to manage, and then we've got block B who haven't claimed the right to manage. So jump in if you want to, but can anyone think of any issues that might arise here where block A have the right to manage? They're obviously managing their block, but they also, whether they wanted to or not, acquired the right to manage all of these pavements and grassed areas, etc., that are in between. So if anyone can think of any issues that might arise in that process, then feel free to jump in, but otherwise I'll take you through some of the issues that I can see. So first issue, here's my Q&A. I will come back to this question on insurance from you, Jane, in a sec. Okay, so we've got, yeah, Block B have no contractual obligations with Block A RTM. So Block A RTM, by virtue of the RTM, have to also manage those pavements and grassed areas. That's going to cost them money, and Block B have no contractual obligation to pay them. So they may refuse, which is going to leave Block A struggling because they can't take any enforcement action against Block B because there's no contractual obligation for them to pay. They equally cannot force the landlord to take action against the leaseholders of Block B because the landlord hasn't done the work, so the landlord can't claim it from the leaseholders. The landlord, however, remains obligated to the leaseholders of Block B to maintain the estate. So the landlord can be sued by Block B if it fails to maintain, but if the landlord does maintain, and we know this from the first bought case, it then can't recover its cost from Block A. So the next question I have, and again, if anyone has read the first bought case, you might know the answer to this, but what would happen if Block B proceeded to acquire the right to manage? So this was argued by counsel for first port, and I think it's a very good point, and I think perhaps had it been argued in Gala Unity, we might have had a different outcome. But Section 73(4) of the Common Hold and Leasehold Reform Act 2002, which is the act that contains the right to manage provisions, says that a company is not an RTM company where there's already an RTM company in place over the premises to which it applies. And of course, premises includes all those estate areas. So in my Block A and Block B example, if Block A have the RTM, they also have the RTM over the estate areas, which means that there's an RTM company in place over the premises. So Block B would be Block B and also those estate areas. So technically there's an RTM company in place already over the premises. So Block B is then prevented from acquiring the right to manage. Now, I suspect if there were a case on those specific facts, the court would find a way of making it work. But one of the comments in the Gala Unity case by the judge was that he appreciated how much of a mess this was creating, but he felt that the consequences of it weren't so grave as to depart from his interpretation of the law. I suspect that actually, if you look at this Section 73(4) point, then if it's to be interpreted that Block B couldn't acquire the right to manage for that reason, then that is a very grave consequence. That's going completely against what the government intended. So yeah, we'll see what happens in round 2 or round 3 of first bought. So anyway, when you're dealing with this sort of issue, what's the solution? How do we get around all these problems with enforcement and people not being obligated to do work and people not being obligated to pay? The key really is, and this is what was suggested by the judge in Gala Unity, was the management agreement. So having a management agreement between the RTM company and the landlord and potentially the other blocks, particularly if there are more than one RTM company on an estate, dealing with who manages which areas, who demands for the payment, who enforces those demands, and who pays who. There's a number of ways this can work, and in my view, whether some landlords want to disrupt the RTM as much as possible, obviously because they want to retain the management of their buildings, but in my view, where there is an RTM being exercised, it's in everyone's interest to try and work together to agree this. So there's a few examples here. I won't take you through all of them, but this is like some of the ways that it could work. So you could have it where the RTM manage the estate, the landlord then pays the RTM from the relevant proportion of estate work. The landlord then demands what he's paid from the other leaseholders, and that then allows the landlord to enforce against them. Alternatively, the right to manage company can manage the estate. The RTM then demands its work from the other leaseholders in the landlord's name, and the RTM enforces in the landlord's name. Now, this all needs to be dealt with in the management agreement, so this is a very simplistic examples of how it might work. But yeah, these are some of the things you can do. The alternative, if for whatever reason you can't agree management agreements, an RTM company and the tenants and a landlord can apply to vary the lease. Bear in mind that you'll only get a variation if the leases are defective. So, this doesn't necessarily work in all cases, but where the service charge provisions are defective, the RTM company can apply to vary those, which might then deal with some of these issues. So making a Section 27A application ahead of works being done. So the landlord might, as I say, be obligated to maintain the estate under the leases of the non-RTM blocks, and they might then apply to the tribunal to get a determination as to whether the RTM has to contribute. We know from first port at the moment that they don't. but it's a solution is to get that determination ahead of time. And then timing. So this is one of the things we'll deal with really is when we'll get approached by an estate as a whole who want to exercise the right to manage. And it's just a case of good timing. So you'll have your Block A RTM, your Block B RTM, your Block C RTM, serve the notice at the same time. That eliminates any risk on the Section 73(4) point because there is no RTM company at present who has rights over those areas. So you serve the notice on all of them. Prior to doing that, you will have put your management agreement together between each RTM company to determine who's doing what and how votes are taken and all of that. Okay, let me just have a quick look at the questions that have come in so far. So can an RTM always place the building insurance? I've taken on RTM recently and the insurance renewal assume we anticipate the landlord will resist this. So the RTM company takes on all management functions in the lease. So placing insurance is a management function. If the lease says that the landlord has to place the insurance, that becomes the RTM's job. So obviously the landlord may be a member of the RTM if it wants to be, if it wanted to be at the time. But yeah, it's for the RTM to do that, if providing it's in the lease, which it should be. So a pertinent property, who would manage the estate? So again, it is fact specific, but the case law says that where there's an RTM company in place over one block, then they technically acquire the management of the estate as well. Obviously, in an ideal world, the RTM company would agree with the landlord who's doing what and how it's all being paid for and by whom. But yeah, technically that does become a management function of the RTM, providing that the premises are actually appurtenant, which will be lease and fact specific. What if there is a concierge service for the development that is housed in Block A? Who runs that and deals with that service? So that will come down to the leases. Arguably that's an estate service, so arguably that would fall to the RTM. But if the leases, for whatever reason, have that structured differently, then it may be the landlord. But my instinct would be that would probably be the RTM company as well. Okay, so let's move on to the problem with finances. I think you're probably mostly aware of all of this, so I'll keep this one brief. But basically an RTM company has no money, so its articles of association are prescribed. There's no ability to demand a cash call from members. If the service charge or the service charge mechanism is insufficient for whatever reason, the RTM company is going to find itself in a deficit pretty quickly. Some service charges are payable in arrears. Now, obviously, that's less and less now, but there's still a healthy amount of leases that require service charges to be paid in arrears. So if you're a RTM company, you're going to have to fund a year's worth of service charges potentially up front. Now, in my view, when I get approached on these kind of developments, I always say, think very carefully about whether you want to proceed with this. There are other management options. And whilst they won't always apply, do you really want to be taking over a property and having to fund a year's worth of arrears up front? A lot of RTM companies will kind of agree that actually we're going to chuck some money into it ahead of time. But if you haven't got 100% participation, that's not going to work either. And you very rarely have 100% participation in these things. So yeah, if you're approached to help with the right to manage or to acquire the right to manage where the service charges are payable in arrears, my advice would be think very carefully. The RTM company, potential RTM company, should think very carefully about whether they want to proceed with that. Most leases do not contain, despite what people think, most leases don't contain an ability to just demand a payment like that. Most leases will work on the basis that you have to project your yearly spend on service charges and then demand it in 2 installments or 4 installments or whatever. It's very rare for a lease to allow you to just demand a payment if the roof falls down, for example. So again, that can cause an issue in these circumstances, particularly if there's no reserve fund. And again, not all leases allow for a reserve fund. So again, it's just something to think about when you're taking over the management, is if the leases don't allow a one-off demand for major works and something catastrophic did happen, then, you know, how is the RTM company going to pay for that? So insolvency is obviously the big risk here. And same things with legal and other professional fees. If the leases don't allow full recovery, then that could leave the RTM in a deficit. And service charge arrears, obviously. I think most people are pretty good at recovering those now, but there's, you know, they can still cause issues. Oh, where's my, okay, here we go. So the solutions, it could be possible to have a shareholders agreement between members that they are going to, as I say, for example, where the service charge is demanded in arrears, actually they're going to pay up front. Variation of leases, now again, to reiterate, that can only really be done where they're defective. And service charges payable in arrears, as an example, isn't necessarily a defect, although it's undesirable. Unsecured lending is an option, but you know, who's really going to want to go for that? I've said enfranchisement there. Really, that's, you know, when you enfranchise, you've got a bit more control over the leases. You can get them to say what you want to a degree, providing you're not stepping on other people's toes or obstructing other people's rights. And then obviously the final one, which no one really wants to do, but it is an option, is just simply walk away and say, do you know what, this isn't going to work. It's not worth the hassle. We'd rather pay a bit extra in our service charges. So the problem with enforcement, obviously a right to manage company cannot forfeit a lease, only the landlord can do that. But what's the problem with that? Well, as I've alluded to, a lot of landlords don't like the right to manage as a remedy for leaseholders. It sucks for the landlord. It's the worst one. At least with enfranchisement, you know, they have nothing more to do with the property, whereas it can be the case with RTM that they have to watch a group of inexperienced people try and manage their building, which can be upsetting. So landlords do try and, or can disrupt the RTM's progress as much as possible. So when enforcement is an issue, a landlord might be inclined to just sit back and let the RTM company deal with it themselves. So obviously, this is dealing with service charge arrears. Mortgage companies will quite often pay where there's a threat of forfeiture. But when that service charge is due to the RTM company, there is no threat of forfeiture, so the mortgage company doesn't have that incentive to pay. Again, legal and professional fees incurred with enforcement might not necessarily be recoverable. And as I've already said, the landlord is unlikely to want to help too much, particularly with service charge arrears, I think. So what options are available? Well, the RTM company can apply for an injunction. Very costly, but it's an option that's there. Obviously, a county court money claim and the typical enforcement options such as high court enforcement, attachment of earnings, but those things aren't hugely successful and they're not particularly quick. And then, as I say, request assistance from the landlord. There are circumstances where the landlord might want to assist. For example, if a tenant's knocked a wall down and that's caused structural issues, then obviously that's going to impact the landlord's investment, so that you know, they won't sit back all the time. And some landlords are very nice and won't sit back at all. But so moving on to knocking walls down, the problem with consent. So leaseholders quite often acquire the right to manage, thinking that they'll then have full control to do what they like, and that simply isn't the case. So when a tenant needs consent under the lease, usually for alterations, also for subletting, it's for the RTM company to give that consent. However, the RTM company does need to give notice to the landlord, and the RTM company cannot give consent if the landlord objects, which then requires applications to the tribunal, etc., to get that resolved. The landlord can dictate conditions. So although it seems like a simple process, actually it can be quite convoluted. Again, it's an opportunity for the landlord to disrupt if they were so inclined. But it is a risk for the RTM company. As I say, it's for the RTM company to give consent. They can't give the consent if the landlord objects. So the tenant would then have to take action against the RTM company for failing to give consent, even though it isn't necessarily the RTM company's fault. So all sorts of problems can arise there. And what's the solution? Well, from a cost perspective, if I were representing an RTM company in a consent claim, I would say, you know, hang on a minute, we're not the ones causing the problem here. You two deal with it amongst yourselves. As I've said there in that slide, and this is really important, be wary of turning a blind eye to works. So the RTM company is under a duty to report any breaches to the landlord. So it can't be like, actually we'll just agree amongst ourselves that we don't need consent to alterations anymore. You know, that can't happen. You've got to comply with the leases, you've got to comply with the full consent process, and if you don't, for whatever reason, then you're under a duty to report that breach to the landlord. Just see if there's any more questions. Not right now. Okay, that's good. Okay, so handover, and as I say, I think some of you will have experience of this, and sometimes it goes swimmingly, other times it doesn't. As I say, I'm trying to avoid going into the real technical legal details, but there is a duty to hand over service charges, and that's uncommitted service charges. So if you have invoices outstanding, then obviously you can retain the service charge funds to get those paid off. But yeah, any uncommitted service charges need to be handed over to the RTM company on the handover date. Landlord doesn't need to hand over any service charges that are in arrears, and we know that from the OMB New Riverhead RTM company case. And as I've said, you know, alluded to in the finance section, arrears can result in the RTM acquiring a deficit and possibly being unable to manage from the outset because it's already insolvent technically. And again, if there's historic poor management, which is one of the drivers for going down this process, that's likely to be the case. The RTM may struggle to fund any work. Obviously, contract handover is dealt with once the landlord served its counter notice accepting the claim. The RTM company can essentially choose whether it takes over contracts. So in most cases, they don't, but you do want to make sure, I mean, particularly if anyone was going ahead without a managing agent, you know, they want to make sure that there is some contracts in place and that work is going to get done. Oh. So yeah, as a managing agent, if you don't comply with the handover process, you are at a risk as a business as well that the RTM company may bring a conversion claim or a trespass to goods claim against you. So just be aware of that. And, you know, once the RTM has been accepted by way of a positive counter notice, then, you know, you really need to be preparing for handover and do as much as you can on the handover date. If for whatever reason you think you're going to struggle, then just be open with your communications with the RTM company and let them know what the issues are. And the chances of them actually bringing a claim are probably quite small if you work with them. So solution to that. So timing is a big one, and I think it's one that people don't often think about. So if you are, the best time to exercise the right to manage is when you've got the bulk of the service charge in advance. So for example, if you're demanding on the 1st of January, and let's say everyone takes about 30 days to pay, so they're all going to be paid up by the 31st of January, then you want to serve your notice so that the handover is going to take place in around March time. Therefore, you're requiring a year's worth or nearly a year's worth of service charges, and the RTM's got a good funding base to get started. Equally, the alternative is to acquire the right to manage just before the budgeting and demanding process. The RTM company can prepare its budget in advance, and then it will take responsibility for those initial demands at the start of the year, and again allow it to proceed straight away with a healthy service charge fund on account. what you probably don't want to do is to acquire the right to manage when there's nothing left. So if you're a month away from year end, for example, and you've got deficits in place and all of that. So, you know, timing is an important one. Let's say it's one that people don't think about, but my advice would be, if you are assisting in this, then time it so that you're going to acquire the right to manage at a time where there's a healthy service charge balance. Assignment of arrears is one that isn't technically dealt with by the Act, but the landlord has obviously the right to retain any arrears. But you can work out an assignment with them if they'll agree. And yeah, be careful with contract terms. So again, if you are taking on contracts, just be wary of when you've got to pay things. And you know, say it's all about just assessing the best time to go for it. Don't just blindly serve a notice without thinking about these things. If it's not desperately urgent, then try and time it so, as I say, that there's a healthy balance and you've got the control over it early on. Okay, so the problem with relationships, and I think this is nearing the end of my thing now, so get thinking of some questions because I've whizzed through that. Problem with relationships. So when a landlord is managing, the tenants bond over their collective dislike of them, and they'll have their whinges in the corridor about how the painting's not been done in 10 years, etc. So that's that can create a real bond amongst leaseholders, and that's what often brings them together to go through these processes, that those little bitches in the corridor will ultimately end up in a successful right to manage claim. But the position very quickly changes when those same neighbours have become the board of an RTM company and start to discuss what they're going to do with management. I'm sure you all know, and I've said there actually in the slide, there's always one leaseholder in every block, so there's always one. There's always one who wants to do his own thing, and I say his, it can be a her as well. They, ignore the leases. They actually want to save some money, so they think, oh, we don't really need to do this right now, whereas other leaseholders say, oh no, it's desperately in need and it's a real priority for me. And those relationships can quickly break down. So obviously, if the relationships deteriorate, the block in itself, so the management and the RTM are at risk. So the real solution there, and I don't know how you'll feel about this, but I think it's the case, is you as a managing agent, you're the one who has really got the ability to manage those relationships, take a bit of ownership, and where there's a disagreement, ultimately you can guide people in a certain direction. So yeah, that's your role in all of this, is managing those relationships. Oh, okay. I do have a brief section on reform. I'm sure you're all sick of hearing about the government reforms to leasehold, and actually the reforms to RTM has taken a slight backseat, but I'm sure it will happen, and I do believe it's necessary. So one of the proposals is that the schemes of leasehold houses can acquire the right to manage. An ability for a single right to manage multiple blocks. Well, obviously that might assist with the issues caused by the Gala Unity case. However, it probably wouldn't help where, say, 4 of 8 decide to claim the right to manage. The revision of the 25% non-residential criteria. I mean, I have real reservations about this one, but there is talk of 25% of the building increasing to 50%, so allowing leaseholders of half of a building effectively to claim the right to manage of the whole thing. So managing 50% commercial, I don't know how that's going to go, but that's the current proposal. Clarification as to the extent of the managed land. Well, I think hopefully I've demonstrated that that's desperately needed. And then clearer rules for the management of property, which is not exclusive to the RTM. So again, particularly with estates, we've got a real mess at the minute in the law, and it does need sorting. So hopefully that will happen. And that's not actually the whole residential litigation team. There's about 8 of us, but that's myself and Simon Foster, who's heads up my team. We deal with RTM, so you've got our details if you need them. And that's it really. So obviously happy to take any questions. As I say, if anyone has any experience or anecdotes that they want to share, please do. I've had a question in saying, could you please explain the concept of service charge in arrears when the landlord doesn't need to hand over? What does that mean in practice? Service charge in arrears means unpaid charges. But yeah, so where the service charge fund is in arrears, the landlord effectively has a lien. So when money's paid over by leaseholders to the RTM company, they're under a duty to account to the landlord for it. If, for example, I mean, keeping things very simplistic, let's say we've got 10 flats and 5 have paid and 5 haven't, then the landlord can theoretically keep the payment from those 5 to fund the 5 who haven't. Another question, aside from the revision of the 25%, as it stands currently, RTM can't be demanded, but can freeholder override and allow RTM if leaseholders request it, if commercial is, say, 30%? Yeah, so when the RTM company claim the right to manage, the landlord has an opportunity to serve a counter notice within 1 month, and that will say whether it accepts the claim or whether it doesn't. There's nothing to stop a landlord accepting a claim that isn't technically valid. So if they want to agree that, then I don't see why they couldn't. Yeah, it's not going to fall apart. So they just need to formally accept the claim, and once they've done that, there's not really anything they can do to back out of that. Okay, is there any
another question? You've got another question from Darren.
Oh,
in
yes.
a scenario where 3 out of 4 blocks on an estate acquire RTM and only 1 doesn't, and are managed by different agents, what is the positive with splitting up the reserve fund that has accumulated for the development as a whole?
Oh, thanks, Darren. That's a really good question. And actually, it's one that I probably don't know the answer to off the top of my head. 3 out of 4 blocks in the estate acquire the RTM and 1 doesn't. Managed by different agents. What's the position? I mean, this is difficult because the estate will fall to 1, if not all 3 of those RTM companies. So as I said with the Gala Unity case, the reserve fund would technically fall under the estate and would therefore be managed by the RTM company. When you've got 3, I mean, the law is a mess, so it doesn't really say who particularly has to take control of that. I'd be interested to know if this is a real example, whether the reserve fund is for both the blocks and the any sort of estate land. If it is, then that's a really tricky one. I mean, I'm sure that you couldn't just split up 75% and 25%. I think the right thing to do in that case would be to have the landlord retain but then that wouldn't work either. I mean, it's a mess, isn't it? I think an agreement amongst themselves would be the right way to go. What the law says, I don't think the law actually deals with this. I think it would say that one of 3 of the RTM companies has to take responsibility for that. I think my preference would be for the landlord to take responsibility for it, and for the RTM company to claim it from the landlord as and when they needed it for the works that it was intended for. But yeah, that's a tricky one. If it is a live example, then obviously feel free to contact me and I'll try and give you a slightly more sensible answer than that. But yeah, off the top of my head, I can't see that the law would deal with this very succinctly, and it probably would come down to an agreement between the parties. Also on the same theme, what happens when leases state that each of 20 flats pay 5%, but 3 of the 5 blocks are RTM and the other is independent of them? It is a mess, agreed, yeah. What happens when leases state that each of 20... So sorry, Darren, do you mean one of the blocks is on a different estate or managed separately? And what is this 5% for? Just service charges generally, I assume. 3 or 4. Oh, okay, fine. Yeah, so the RTM blocks would pay their 5% to the RTM company, because it's the RTM company who are responsible for managing the estate, even if they don't in practice. But again, it probably comes down to whether you can get something agreed with the landlord about that other block that hasn't got the RTM. But yeah, I think the technical position would be that the leaseholders pay their proportion to their RTM company. The others would pay to the landlord. But how that money is spent and dealt with, you know, it's going to have to come to an agreement between all 4, so all 3 RTM companies plus the landlord, I think. I can't really see any other way of doing with it all, or the variation of the leases, so that each party has, certainly for the block itself, can manage its own reserve fund. But again, we can't really say that the leases are defective, so whether or not such an application would be successful is to be seen. But I imagine if there was sufficient consent, then you'd probably get that through. But yeah, that doesn't sound like a fun block or development. So good luck. But contact me if you need anything else. As I say, I'm happy to have a closer look at it if it is causing problems. Right, I can't see any more. If anyone has anything, then obviously stick it in now.
That was quite a tricky question there. And
yeah, I know.
Is that a situation where we did a session yesterday on mediation? Is that the kind of problem that could be solved with a mediation?
Yeah, absolutely. I mean, I think that's the only way it can be solved, really, is some sort of discussion. At least, if you know, formal mediation might not be necessary. It might be that everyone can just agree, you know what, this doesn't work for any of us, so let's find something that does. But yeah, mediation would be an option. You know, it's really only going to work if the parties come together and agree something. I assume that the RTM companies are all on one side, and then it's the landlord on the other. But yeah, it's some discussion is needed, I think, to resolve that one.
No, definitely. Oh, well, look, that's excellent. That was a really, really informative session. There's so much information there.
Yeah, I'm sorry, I felt like I whizzed through it. It did take a bit longer in practice. So if anything wasn't clear, obviously people are free to contact me, and you know, any specific queries, I'm happy to answer them.
No, that's great. Well, we'll be sending out your presentation material to everybody after the session, and also your contact details. So if anybody wants to contact you directly, they can. So that's always the best way forward. Well, look, thank you so much for taking the time today to talk to us. Later today, we're going to be talking to Yashmin Mystery from JPC, and we're going to be discussing reading a lease, and that's at 2 o'clock this afternoon. So thank you so much for your time today, and thank you very much, everybody, and hopefully we'll see some of you this afternoon. Thank you very much.
Thank you. Have a good day.
Bye-bye.
Bye.